If you're looking to invest in Missouri probate properties, this video is going to save you time, money, and legal headaches. Hi, my name is Deanne Schnurbush. I'm an estate and probate attorney out of St. Charles, Missouri, and I help people all across the state of Missouri deal with the probate process. And we run into a lot of real estate investors who are interested in buying properties from probate or buying properties from somebody when somebody has passed away, because sometimes you can get a discount. You can get a better rate of a better deal on your property when the buyers are motivated to get rid of it, right? And having a property in probate is one of those situations where buyers tend to be motivated to get rid of the property as soon as possible. So this is going to be kind of structured as a checklist of things that you need to do when evaluating a property and deciding whether this is something that you want to proceed with. So the first thing you need to do is you need to evaluate the ownership of the property. And this will give you an insight into who actually has authority to sell and who you should actually be talking to in dealing with this property. If you've got a deceased person on the title to the property and you're talking to their sister and they still have living children, you're talking to the wrong people in most cases. So let's go through what this looks like. So the first thing I encourage you to do is look into getting a title report. Build a relationship with the title company so that you can get a clear understanding of who is actually on that title when it comes time to determine who you need to talk to and what kind of steps are going to need to be taken to bring that property to closing. So what you might find on that title report might dramatically change what you decide to do in this situation. So for example, let's say you have a piece of property and it is owned by two people. Well, it depends who those two people are. Let's figure out who the owner is. So let's say that they are not related to one another and they own it as what's called tenancy in common, because it doesn't specify on the deed joint tenancy with right of survivorship. In that kind of situation, you have a tenancy in common between two people. If one of them is deceased, you may need to have probate. You may need to go to probate or have the family go to probate in order to deal with that tenancy in common interest. Now, if the deed specifies that it says that the two co-owners own it as joint tenants with right of survivorship, whenever that deceased person passed away, generally speaking, their interest is going to pass over to the other surviving joint tenants. And that's the way joint tenancy works, and that's how it's different from tenancy in common. A tenancy in common, you have divided interest in that property. You may have a 50% interest and a 50% interest. In a tenancy in common, when somebody dies, that property interest passes to their probate estate to be passed to their heirs at law or to be passed under their will. If you have a joint tenancy with right of survivorship, everybody owns an undivided interest in the whole. So when one of them dies, they simply drop out, and the rest of the property slides over and belongs to the rest of the joint owners, right? And a very similar kind of co-ownership, of joint ownership in the state of Missouri, is tenancy by the entirety. And this is a form of joint tenancy, but it's only between married couples. It's very similar. It works the exact same way as joint tenancy with right of survivorship, except for it adds a layer of asset protection from the debts of any one spouse. If one spouse gets sued or has to file bankruptcy, that property, as long as it's held as a married couple, as tenants by the entirety, is protected from the debts of any one spouse, okay? Now, it's important to understand that between unmarried co-owners, the default form of co-ownership is tenancy in common. So if you don't have that magic language as joint tenants with right of survivorship, then you can assume it's probably a tenancy in common. And if there's a deceased co-owner, you probably have to go to probate for that person. The opposite is true between married couples. The default presumption is that it's going to be tenancy by the entirety with that survivorship right, not a tenancy in common. So it's very important to understand, was the co-owner married, that kind of thing. And you can understand what happened to that property when that person died. The title company may be able to help you with this as well. Okay? Other forms of co-ownership or other things to look out for on that title report. If you see a beneficiary deed recorded, if that shows up in the title report, you may have a beneficiary situation on your hands where the property may have transferred without the need for probate to a designated beneficiary. So if that's the case, you may need to figure out who that person is. Are they still alive? Where are they? Can I talk to them? Do they have the authority to sell? Right? So figuring out exactly who owns the property is sometimes the most important first step. But let's talk about a classic probate situation. Okay, we have a house owned by a single person, no joint owners, no spouse, no beneficiary deed. It's just in their name, and it's not in the name of a trust. That's probate property in most situations. that's going to need to go through probate in order to transfer to the heirs, okay? And that is where we get into checklist step number 2, is evaluating the probate status of the property. So first we need to figure out, when is probate required? So probate is only required on a piece of property if it is left in a deceased person's name and has no beneficiary, has no joint owner, has no other automatic way of transferring, okay? So if you don't see anything like that in the title, and you can usually determine all of this from the deed records and from that title report, whether that property has an automatic method of transfer. And normally if it's in an individual person's name and you don't see a beneficiary, probably going to be going through probate, okay? So then we get into the question of what kind of probate is necessary. You're going to want to make sure that you look at a couple of things. We need to look at what is the value of the estate and how long has it been since the owner died, okay? This is going to affect how long you can expect until you reach closing on that property. So let's say it's under $40,000 in net equity on that property, and there's no other meaningful assets in the estate because you've talked to the next of kin, maybe you've talked to the spouse or the children, and you've determined there weren't any other pieces of property. This is the whole thing. So if you know the value of the mortgage, you can roughly compute the net equity, and that'll give you an idea of how valuable the probate estate is. If it's under $40,000, the estate will probably qualify for small estate treatment in most cases. Now in Missouri, this is generally a faster process, and from your perspective, it is a little bit faster process than any other kind of probate. Usually that can be resolved anywhere from 4 to 8 weeks, sometimes a little bit quicker depending on which county you're in. And once that application is filed, and it must be filed through an attorney in most cases, and recorded with the Recorder of Deeds office, that will serve as valid evidence of the chain of title transferring from the deceased person to your seller, okay? And then you can go to close and they can issue you a deed into your name or the name of your LLC or whatever you're using to buy it in. If the estate value exceeds $40,000 and we're within 1 year of death, we're probably looking at a full probate administration, all right? Now, if it exceeds $40,000 and it has been longer than 1 year, we can look at a tool like a determination of heirship. This process usually takes 8 to 10 weeks because we've got to publish in the newspaper and have a court hearing. But as soon as that's over, you can go ahead and buy from the heirs as the sellers. Now, a full probate administration process, when handled from start to finish, usually takes about a year. But that doesn't mean that you can't buy the property for a year. Generally, what it means is that the family members or whoever the representative is that's going to be appointed, they can't sell it until they are issued what are called letters of administration, if there is no will, or letters testamentary, if there is a will, all right? And there is a valid will. It's important to note in Missouri, a will is only valid if filed for probate within 1 year of death, okay? So if they wait too long, it's no longer valid as a will. That's another important piece to think about when you're talking to a seller is if their only claim to the property is under a will and they're not like a child or something else, it's important to understand, was that will taken to probate and admitted to probate? If not, it has no authority after 1 year of death, okay? In a full administration, time to letters is usually anywhere between 4 to 8 weeks, similar to some of the other processes. Once you get that, generally that seller, that personal representative after appointment can generally go ahead and sell that property. Now, whether or not they need to apply for a petition to the court to get the authority depends on whether they're serving in a supervised or independent capacity. But in most cases, we can get that petition on file and get that order done within 8 to 10 weeks of them retaining us, okay? Most of that time period is just waiting on the court to review the application and set it for hearing and so on, if a hearing is required. So what should be some takeaways for you? You definitely need to be patient. When you're dealing with probate, you need to anticipate that it's going to take a little while to close. And in some cases, these timelines that I'm giving you are best case scenarios. It could be something could go completely sideways and it could take a very long time to get somebody appointed. Or there may be complications or disputes with the heirs or some other issue that cause it to take longer. So you got to be patient when you're dealing with probate. Make sure you understand your numbers and that they make sense at the time that you lock in a contract price, okay? So get that, just get that out of the way. That in many cases, it's not going to be a quick close, but in many cases, you will be getting a good deal. So something to keep in mind. All right, so build in flexibility. Make sure your contract anticipates that. Be ready for the possibility of an extension or moving the closing deadline. Don't hold your seller tight on that. As somebody who represents sellers, I can tell you there are all kinds of different situations where probate is going to cause a delay, all right? And it's very annoying when your probate buyer is causing a big fit or your title company is throwing a big fit because we need to move closing. Sometimes we just have to, things come up and we just have to move closing, okay? So be flexible, right? Be flexible and protect yourself in your contract instead of relying on specific deadlines or specific dates for things to the best of your ability. The other thing you're going to want to figure out is how are you going to handle legal fees? Sometimes these sellers don't have money to pay upfront. In many cases, you will either need to front the fees or you will need to be ready to have them paid out at closing and come to an arrangement with your seller. Are they going to shoulder the fees? Are you going to shoulder the fees? Is it going to come out at selling or at closing? Or is it going to come out of the estate? Where are the legal fees getting paid from? So make sure you have an understanding with that about that with your buyer. And also keep in mind that can be a point of negotiation, right? So you can use that as a negotiating piece with a potential probate buyer or seller in order to help close a deal. All right, something else to push on and think about. So whenever you're approaching, to summarize, whenever you're approaching a probate property, make sure you understand who actually owns that property. Before you start negotiating with people and trying to get people under contract, try and figure out who actually does or could have the authority to sell that property. That's mostly going to be helpful. The most helpful way to get that information is to get a title report, and in many cases, you may want to run it by your partner probate attorney. And that's the last thing I want to suggest. If you're interested in investing in Missouri real estate, probate real estate, you need to partner with a Missouri probate attorney, somebody who you can bounce questions off of, and somebody who you can bring to that you can trust to efficiently administer those estates and get you to close as fast as you can. All right. Now, ultimately, that attorney owes his duties and allegiance, his or her duties and allegiance to the client, to the seller, to the probate person property. But if you know that you can trust this person to do a good job, to get the estate open, to move it along and get it done, that's a very important and very valuable partner to have in your corner. Because the reality is in probate, a lot of times, if you have somebody who doesn't really specialize in probate, they'll dabble in it, they haven't built the systems and processes to be able to execute on these things efficiently. There's a dramatic difference between working with somebody who's a generalist and somebody who specializes in probate and trust administration, right? And in our experience, many of the delays you see in probate are oftentimes the fault of the attorney, despite what they may tell you. So it is a good idea to work with somebody who specializes in probate and knows these processes because they can head off problems long before they're an issue. They can perform those heirship evaluations and understand the rights and who's actually entitled to what long before you could run into any problems. And they can help cut off a bad deal. They can help you identify a bad deal. We had one the other day where we had a property come in and it turned out it was going to get divided into too many fractional shares that the sellers didn't realize was going to be a problem. And it ended up not making sense. The sellers decided we're not going to bother going through probate. It's not that important to us. We're not going to make enough money. So even if that's a bummer of an answer, at least you got that answer right away so you can cut that off and move on to the next deal rather than wasting time and energy on something that's just not going to pan out. So if you enjoyed this content, again, my name is Dan Schnurbush. We represent clients and deal with probate all across the state of Missouri. If you found this valuable, don't hesitate to submit the form down in the description where you can join our mailing list and learn more about Missouri probate. One of the things that you'll also receive by submitting that form is a PDF checklist of all the things that you need to worry about and think about when you are evaluating a probate property for purchase. And it's geared more toward understanding the probate elements. I'm not going to give you opinions on, how much you should offer or what sorts of things you should factor in that sense, but you need to understand what you're getting into whenever you're buying a probate property so that you can make informed decisions about how much you're going to offer, what you're going to do, what kinds of things you're going to work out with the seller. All right. So if you enjoyed this content, check out some of our other videos, like and subscribe, and we'll see you next time. Thanks, guys.